Good day everyone. My name is Jade Claire G. Downing and I'm going to discuss about the laws related to tourism investment and finance on chapter 12. So the learning objectives would be: first, enumerate the procedure in setting up a tourism-oriented business. Next is to explain the laws governing tourism investments and financing tourism-oriented projects. Discuss the business models applicable to the tourism projects, then enumerate the various taxes application to tourism-related establishment. Lastly is to discuss the limitation of foreigners in tourism investments. So for the topic outline, first is the Foreign Investments Act of 1991, procedure for registration, limitation of foreign ownership, investment in transportation, business and public utilities, investment in travel agencies and tour operators, investment in hotels, resorts, and other accommodation establishments, application of the retail trade law for restaurants and shops, tourism projects under the Build, Operate, and Transfer program, then period covered, financing allowed, employment of Filipino workers, priority projects, preference to Filipino contractors, registration with the Board of Investments, investment incentives, and government undertakings under the BOT law, then applicable negotiable instruments and documents of the title, other commercial documents, and foreign exchange regulations, financing, promissory note, then credit line agreement, real estate mortgage, chattel mortgage, surety agreement, trust receipt, letter of receipt, credit cards, rules on renewal, access device fraud, then fraud commissions, investment priorities plan, autonomous region in Muslim Mindanao, list incentives, then income tax holiday, exemption from taxes and duties on imported spare parts, exemption from wharfage dues and export tax, duty, imposed and fees, tax exemption on breeding stocks and genetic materials, tax credits, additional deductions from taxable income, non-fiscal incentives are as follows: then lease of private lands, Special Economic Zone Act of 1995, Republic Act 7916, business models, franchising, time sharing, taxes, value-added taxes, percentage taxes, excise taxes, customs and import duties, travel taxes, duty-free Philippines, barangay micro business enterprise law. So it has been the policy of the state to recognize the indispensable role of the private sector, like the tourism industry, and provide incentives for its needed investments. So this chapter deals with laws related to promotion, monitoring, and regulation of tourism investments and finance in the country. So basically, this will tackle the participation of foreign investors as well as incentives given to the Filipinos in case they will invest in the tourism industry. Special laws are even created to address needs of certain sectors like the informal sector, Filipino balikbayans, retirees, and senior citizens. Foreign exchange. The Foreign Investments Act of 1991, as amended by Republic Act 8179, allows for foreigners to invest in all activities and enterprises in the Philippines, except those covered in the negative list. So, a Philippine national is defined as a citizen or a corporation with at least 60% Filipino ownership, and certain small and medium-sized enterprises are reserved for Philippine nationals unless they involve advanced technology or employ at least 50 employees. So foreigners can show up to 100% of a domestic market enterprise if their investment is at least USD dollars, $200,000. But if it involves advanced technology or meets employment criteria, the threshold is reduced to $100,000. So export enterprises which export at least 60% of their output may have up to 100% foreign ownership unless restricted by the negative list or specific laws. The Act outlines activities considered as doing business in the Philippines but clarifies that mere investment as a shareholder is not considered doing business. Procedure for registration. Foreign national or entities not seeking incentives under the Omnibus Investment Code must register their business in the Philippines. Corporations and partnership must apply with the Securities and Exchange Commission by submitting various documents including a name verification slip, board board resolution, financial statements, articles of incorporation or partnership, and proof of inward remittances. New domestic corporations or partnerships also need to submit articles of incorporation or partnership, a name verification slip, a bank certificate of deposit, a special investor's resident visa, and proof of inward remittance. Single or sole proprietorships must register with the Bureau of Trade Regulation and Consumer Protection under the Department of Trade and Industry. Additionally, the Section 125 of this Corporation Code requires foreign corporations to secure a license from the SEC to legally operate in the Philippines. Limitation of foreign ownership. The Foreign Investment Act and related laws impose limitations on foreign ownership in the Philippines, particularly in sensitive sectors like media, natural resources, land ownership, and public utilities. Foreign ownership is entirely prohibited in industries like mass media, retail, trade, cooperatives, and certain professional services. In most cases, foreign ownership is capped at 40%, especially for areas like natural resource utilization, public utilities, and educational institutions, unless a special agreement or license allows higher foreign equity. Specific industries related to defense, security, health, and more protection are also limited to a maximum of 40% foreign ownership. So if a foreigner wishes to enter a restricted sector like air transportation, they must either partner with Filipino citizens or form a corporation with a maximum of 40% foreign ownership. Investment in transportation, business, and public utilities. Article 7, Section 11 of the Philippine Constitution states that only Filipino citizens or corporations with at least 60% Filipino ownership can be granted authorization to operate public utilities, with such franchises limited to a maximum of 50 years. The law ensures that foreign ownership is restricted to 40% and mandates that all executive and managing officers of public utilities must be Filipino citizens. So, additionally, the Congress reserves the right to amend, alter, or repeal such franchises if required for the common good. For common carriers like airlines and transportation businesses, foreign participation is limited to 40% of total equity, and only Filipino citizens can hold executive and managerial positions. In the case of Virginia Perez, as a Filipino citizen, she can operate a transportation business as a sole proprietor or form a partnership or corporation, ensuring that foreign ownership does not exceed 40% if she chooses the latter. Investment in travel agencies and tour operators. Under the Philippine law, only Filipino citizens, partnerships with at least 60% Filipino ownership, or corporations with at least 60% Filipino-owned voting shares and board of directors can be accredited as travel agencies or tour operators. Foreign participation in this industry is limited to 40% as mandated by the Department of Tourism and the Omnibus Investment Code. To be eligible for registration under the Investment Priorities Plan, applicants must meet the 60% Filipino ownership requirement and prove their capability to contribute to national development. Foreign investors like Mr. Francois Renault cannot operate a travel agency as a sole proprietor, but may form a partnership or corporation under the Philippine laws with a maximum of 40% foreign equity. Compliance with these ownership restrictions is necessary to legally establish a travel agency in the Philippines. Investment in hotels, resorts, and other accommodation establishments. Under Philippine law, tourism-related investments like hotels, resorts, and other accommodation facilities are classified as preferred activities under the Investment Priorities Plan. To be eligible for registration, a minimum of 60% of capital stock must be owned and controlled by Filipino citizens, whether in partnerships or corporations. Additionally, at least 60% of the board of directors must be Filipino, and the applicant must prove their ability to contribute to national development. In the case of Martha Soriano's hotel investment, she needs to ensure that at least 60% of the 20 million total capitalization is owned by Filipinos. To meet this requirement, she can either borrow 2 million or bring in another Filipino investor to maintain the necessary ownership percentage. Application of the Retail Trade Law for restaurants and shops. Under the Retail Trade Liberalization Act of 2000, foreign investors can engage in retail trade, including restaurants and shops, subject to capital requirements. Certain exemptions allow 100% foreign ownership, such as manufacturers selling their own products, single outlet operations by manufacturers, and restaurants incidental to hotel businesses. For Mr. Chek O Teng, he has the three options: register as a sole proprietor, as a sole proprietor under the Retail Trade Liberalization Act with appropriate capital, form a partnership or corporation with up to 40% foreign ownership, or establish a restaurant linked to a hotel to qualify for full ownership exemption. By partnering with a hotel owner, Mr. Tang can avoid a foreign ownership limitation. However, if he pursues a standalone restaurant, he must comply with a 40% foreign equity restriction. Tourism projects under the Build, Operate, and Transfer program. The law. So the Republic Act number 6987, as amended by Republic Act 7718, referred to as the BOT law, implements the declared policy of the state to recognize the indispensable role of the private sector as the main engine for national growth and development, and provide the most appropriate for favorable incentives to mobilize the private resources for the purpose. So the coverage of the BOT law extended not merely to government infrastructure projects but also to government development projects. So the following are the schemes recognized under the law. Build and transfer. Private sector funds and builds a project, then transfers ownership to the government, which repays the investment. Build, lease, and transfer, or BLT. Private sector builds or leases the facilities to the government before transferring ownership. Build, own, and operate. Private sector finances, owns, and operates the facilities, collecting fees from users. Build, operate, and transfer, or BOT. Private sector builds, operates, and maintains a facility, charging users until it is transferred to the government. Then build, transfer, and operate, or BTO. Private sector builds and transfers ownership to the government but continues to operate the facilities. Contract, add, and operate, or CAO. Private sector expands an existing facility and operates it under the franchise period. Then develop, operate, and transfer, or DOT. Private sector builds a project and develops surrounding areas to benefit from increased value. Rehabilitate, operate, and transfer, or ROT. Private sector refurbishes, operates, and eventually transfer an existing facility to the government. Then lastly is rehabilitate, own, and operate. Private sector refurbishes and operates a facility indefinitely unless franchise terms are violated. Period covered. The contractor transferred the facility to the government unit concerned at the end of the fixed term, which shall not exceed 50 years. Then financing allowed. So for the construction stage, contractor may obtain financing from foreign and domestic sources and engage the services of a foreign or Filipino contractor. The financing of foreign or foreign-controlled contractors from Philippine government financing institutions shall not exceed 20% of the total cost of infrastructure, facility, or project. The financing from foreign sources shall not require a guarantee by the government or by government-owned and controlled corporations. Then employed of Filipino workers. In the case of foreign contractors, Filipino labor shall be employed or hired in the different phases of the construction where Filipino skills are available. Priority projects. All concerned infrastructure agencies, including government-owned and controlled corporations and local government units, shall include in their infrastructure programs those priority projects that may be financed, constructed, operated, and maintained by the private sector. Under Joint Resolution number 3, passed by Congress, the following have been classified as national priority infrastructure projects related to tourism. So first is highways, including expressways, roads, bridges, interchanges, tunnels, and related facilities. Next is rail-based projects packaged with commercial development opportunities, like for example, use of government facilities. Then next is non-rail-based mass transit facilities, navigable inland waterways, and related facilities. Then port infrastructure like piers, wharves, quays, and storage, handling ferry services and related facilities. Then airport, air navigation and related facilities, and tourism, educational, and health infrastructure. Then land reclamation, dredging, and other related development facilities. Then industrial estates, regional industrial centers, and export processing zones, and development of new town sites and communities and related facilities. Preference to Filipino contractors. In order to accord preference, a Filipino contractor is required to submit an equally advantageous bid with the same price and technical specifications as that of the foreign contractor. A Filipino contractor will not be accorded to preference unless his bid is at par and on both price and technical aspects with that of the foreign contractor. So in registration with the Board of Investments, Republic Act 7718 provides that projects costing in excess of 1 billion shall be registered with the Board of Investments and entitled to the incentives provided under the Omnibus Investment Code. So for projects undertaken as authorized under the revised internal rules costing 1 billion or less may upon registration with the BOL avail of incentives provided under the Omnibus Investment Code, subject to the inclusion of the project activity in the current investment priorities plan of the BOI. Investment incentives and government undertakings under the BOT law. Under the BOT law, the government may provide investment incentives such as cost sharing, covering up to 50% of project incentive costs, then credit enhancement, guarantees to mitigate the financial risk, and redirect subsidies, shouldering expenses, tax exemptions, or fee waivers. It can also offer direct equity, government shareholding in project companies, performance undertakings, guaranteeing agency obligations, and legal or security assistance, legal representation, and or security development. Local government units like LGUs may grant additional tax incentives under the Local Government Code. Applicable negotiable instruments and documents of the title. So the Negotiable Instruments Law, Act 2031, Trust Receipts Law, and Warehouse Receipt Law, Act 2137, govern negotiable instruments and documents of the title in tourism investment. So the key instruments include promissory notes, bills of exchange, and checks, with special types such as certified checks, then manager's checks, and traveler's checks, which facilitates financial transactions. In disputes like forged endorsements, collecting banks bear responsibilities for verifying authenticity, as seen in the Equitable Banking Corporation versus Banco de Oro case, where BDO was held liable for wrongful payments. Other commercial documents such as invoice, a written account detailing merchandise shipped, including prices and charges. So the sales invoice, a record of the agreed sale terms between buyer and seller. Then purchase order, a legally binding contract for goods issued by the buyer and accepted by the supplier. Bill of lading, a carrier-issued document that serves as both a receipt and a contract for goods transport. Then warehouse receipt, a document proving stored goods which can be transferred as a form of security. Trust receipt, a financing tool where a bank retains ownership of goods while the borrower sells them. Letter of credit, a bank-issued guarantee ensuring payment to a seller upon fulfillment of conditions. Foreign exchange. So the foreign exchange refers to the use of currency, checks, bills of exchange, and electronic transfer for international payments. Under Philippine law, debts must be paid in legal tender, such as Philippine pesos, or unless otherwise agreed, but checks and similar instruments only constitute payment once in cash. Therefore, a creditor can legally refuse payment by check, even if it is valid. Then foreign exchange regulations. Foreign exchange regulations in the Philippines allow the free trade of foreign currency, including deposits in local or overseas accounts under the Central Bank Circular number 1353. Authorized agents banks can sell the foreign exchange without prior approval, and a certain tourism-related business must report their foreign exchange transactions to the central bank. Deluxe hotels in Metro Manila set their exchange rates based on the Bankers Association of the Philippines, adjusting them by $2 to manage fluctuations. Financing. The General Banking Law of 2000 recognizes the crucial role of banks in economic development and mandates high standards of integrity. Banks provide financial services such as savings, loans, and credit, earning profits by investing customer deposits while being strictly regulated by the Bangko Sentral ng Pilipinas. Before approving loans, banks must conduct due diligence, ensuring the borrower can meet financial obligations and providing collateral options like real property, chattels, or deposits. Loan approvals also require financial documents, including incorporation papers and financial statements to assess the borrower's financial stabilities. A thorough credit investigation report helps banks determine law eligibility with final approval based on collateral valuation. The following are the commercial documents which are usually necessary and required in the processing of loan availment in favor of the borrower or corporation. So first is promissory note, credit line agreement, real estate mortgage, chattel mortgage, surety agreement, letter of credit, trust receipt. So as part of the regulation of the government, the bank, a person extending a credit must give the debtor borrower in writing a recital of the following upon extending a loan, such as cash price, the amount credited if on installment price, difference between cash and installment price, and recital of finance charges of and what these charges bear to the amount to be financed in percentage. Promissory note. So a promissory note outlines the principal loan amount, which cannot exceed 30% of the bank's net worth when lending to a corporation unless the monetary board permits otherwise. The interest rate, typically ranging from 9% to 13%, is determined based on factors like inflation, transfer pool rates, and the cost of money. It also grants the bank the right to deduct payments from the borrower's deposits in case of defaults and include attorney's fees and penalty charges to protect the lender rather than. For the credit line agreement, so a credit line agreement is a voluntary contract where the borrower accepts the lender's terms to receive credit accommodation. So specifying the principal amount and type of credit line, such as a letter of credit or trust receipt for import or export transactions. It includes provisions on collateral, repayment terms, interest rates, and the bank's authority to debit unpaid amounts or sell collateral in case of default. The agreement also outlines the liability for subsidiaries, the validity of the bank's records, legal fees, penalties, and the designated venue for litigation. Real estate mortgage. So a real estate mortgage is a contract where a borrower pledges real property as security for a loan, detailing the property description, loan amount, and the borrower's obligation to cover related expenses. It includes provisions ensuring that successors are bound to by the mortgage, the bank's authority to act in case of default, and restrictions on leasing or encumbering the property without consent. The agreement must be notarized and registered, confirming that the property is free or of prior claims and outlining penalties, foreclosure procedures, and possible changes in the interest rates. So in chattel mortgage, a chattel mortgage follows the same stipulations as a real estate mortgage but applies to movable property instead of real estate. It includes an affidavit of good faith where both parties swear that the mortgage is made solely to secure the specified obligations and not for the fraudulent purposes. Surety agreement. A surety agreement requires at least 51% of corporations controlling stockholders to sign, making them solidarily liable for their corporation loans. Then this ensures that in case of default, the creditor can go after both the corporate and personal assets of the surety. And while also encouraging responsible use and repayment of the loan, some banks offer a continuing suretyship agreement to valued corporate clients, allowing them to access credit lines without the usual 6 months waiting period based on factors like industry status and credit history. For the trust receipt, the description of the merchandise with reference to the bill of lading, so the term of the trust receipt, and undertaking of the entrustee that he merely holds the merchandise subject of the trust receipt in trust from the entrustor bank, and that the entrustee is authorized to sell the goods and apply the proceeds for the full payment of his liability with the bank. Credit cards. A credit card is a financial tool that allows users to purchase goods and services on credit. As defined under the Access Devices Regulations Act, RA 8484, this law regulates credit card transactions by outlining the rights and liabilities of users and issuers, requiring clear disclosure of fees, interest rates, and terms before account opening. However, certain disclosure may be waived in telephone solicitations if no fees are imposed, and written terms must be provided before card activation. So in rules on renewal, so credit card issuers must provide clear disclosures before renewing an account if any fees apply, so including the expiration date, renewal terms, and annual percentage rate at least 30 days before the renewal. So these disclosures are not required if no fees are charged or if the renewal occurs through telephone solicitation. So the disclosure can be made either before charging the fee or through a billing statement, giving the consumer 30 days to cancel the renewal without paying the fee. Access device fraud. Access device fraud refers to illegal activities involving the misuse of access devices, such as credit cards, for fraudulent purposes. So the law enumerates various forms of fraud, including producing or using counterfeit access devices, trafficking in unauthorized devices, or altering transaction records. Other offenses include unauthorized possession of access devices or related materials, as well as soliciting, selling, or using access devices without permission from the issuer with the intent to defraud or gain value. So the fraud commissions. Fraud commissions in tourism financing are governed by the revised penal code, which penalize crimes like falsification of commercial documents and theft. So falsification occurs when a private individual alters or forges business-related documents such as checks, letters of credit, or negotiable instruments to commit fraud. Theft, including qualified theft, involves unlawfully taking another person's property without consent, with the latter being more severe when committed with grave abuse of confidence. Investment Priorities Plan. The Investment Priorities Plan, issued annually by the Board of Investments, identifies key industries eligible for government incentives under the Omnibus Investment Code of 1987. So, the tourism-related activities classified as priority investment areas include agribusiness, healthcare and wellness services, ICT, infrastructure, and tourism economic zones. Other eligible sectors include motor vehicle production, shipbuilding, jewelry manufacturing, and fashion garment production, all aimed at boosting economic growth and development. Autonomous Region in Muslim Mindanao list. The Autonomous Region in Muslim Mindanao list identifies tourism-related priority activities eligible for incentives as determined by the Regional Board of Investments, ARMM. These include export activities, infrastructures, and services like public utilities, telecommunications, and tourism development, such as estates, accommodation, and transport facilities. Additionally, key tourist destinations in Sulu, Tawi-Tawi, Lanao del Sur, Maguindanao, and Basilan have been recognized for further exploration and development. Incentives. Under Book of the Omnibus Investment Codes, an investor may enjoy certain benefits and certain incentives provided he invests in preferred areas of investments found in the current investment priorities plan. So, fiscal incentives include the following. So first is income tax holiday, exemption from taxes and duties on imported spare parts, exemption from wharfage dues and export tax duty, imposts and fees, tax exemption on breeding stocks and genetic materials, tax credits, additional deductions from taxable income. Income tax holiday. The income tax holiday grants BOI registered enterprises exemptions from income taxes for a set period based on project classifications, with pioneer projects enjoying 6 years, non-pioneer projects 4 years, and expansions or modernization projects 3 years. So, additional incentives are available for projects in less developed areas and those meeting criteria like high indigenous raw material use, capital to labor ratio, and foreign exchange savings. However, the maximum ITH period for pioneer firms is capped at 8 years. So, exemption from taxes and duties on imported spare parts. A registered enterprise with a bonded manufacturing warehouse shall be exempt from customs duties and national internal revenue taxes on its importation of required supplies or spare parts for consigned equipment or those imported with incentives. Exemption from wharfage dues and export tax duty, imposts, and fees. All enterprises registered under the IPP will be given a 10 years period from the date of registration to avail of the exemption from wharfage dues and any export tax, imposts, and fees on its non-traditional export products. Tax exemption on breeding stocks and genetic materials. Agricultural procedures will be exempted from the payment of all taxes and duties on their importation of breeding stocks and genetic materials within 10 years from the date of registration or commercial operation. The tax credits. Tax credits provides financial relief to BOI registered enterprises by reimbursing certain taxes and duties. Agricultural producers can receive a 100% tax credit on national internal revenue taxes and customs duties for local breeding stocks within 10 years from registration or commercial operation. Additionally, registered enterprises exporting products can claim a tax credit or for taxes and duties paid on raw materials, supplies, and semi-manufactured goods from that part of their export products. Additional deduction from taxable income. Additional deductions from taxable income provides incentives for businesses to invest in labor and infrastructure. Enterprises can deduct 50% of wages paid to additional direct labor force workers for the first 5 years, with the deduction doubled if the business is in a less developed area, though this cannot be availed alongside the income tax holiday. Additionally, business in LDAs or areas lacking infrastructure can deduct expenses incurred in developing major infrastructure projects, except for mining and forestry related enterprises. Non-fiscal incentives are as follows. So, employment of foreign nationals. A registered enterprise may be allowed to employ foreign nationals in supervisory, technical, or advisory positions for 5 years from date of registration. So the position of president, general manager, and treasurer of foreign-owned registered enterprises or their equivalent shall, however, not be subject to the foregoing limitations. List of private lands. Foreign investors investing the Philippines can now lease private lands for up to 75 years. Based on Republic Act number 7652, entitled investors lease agreements may be entered into the Filipino landowners. Lease period is 50 years, renewable once for another 25 years. Special Economic Zone of Act of 1995, Republic Act of 7916. So the Special Economic Zone Act of 1995, or RA 7916, establishes PEZA to oversee special economic zones as granting incentives like tax breaks, 400% foreign ownerships, and duty-free importation to tourism and business enterprises. A related law, or Public Act 7922, created the Cagayan Economic Zone, allowing foreign investors with 150,000 capital to gain permanent residency and unrestricted movement within the zone. So these laws are constitutional as they align with the 1987 Philippine Constitution's policy of encouraging private enterprises, attracting investments, and boosting economic growth. Business models. A joint venture is a business arrangement where two or more parties agree to share resources, risk, and profits for a common project, often without forming a separate legal entity. While it resembles a partnership, a joint venture is usually temporary and does not always have a judicial personality, except in construction or energy projects, where it receives special tax treatment. The law recognizes that joint ventures can help Filipino businesses access foreign expertise, but also warns against potential takeovers by foreigner partners. So, emphasizing the need for legal safeguards, especially in the industry with ownership restrictions for Filipinos. Management contracts. A management contract is an agreement where one corporation delegates the management of its operations to another corporation for a specified period. It involves various functions such as technical operations, personnel management, and marketing, often for industries like hotels or airlines with fees based on revenues or profits. This type of arrangement allows businesses to benefit from expertise and economies of scale, often seen in foreign-owned hotel chains in the Philippines, where foreign companies provide the management services in exchange for a share of profits, as seen in the case of Hyatt Regency Manila and Hyatt International Corporation. Franchising. Franchising is a business model where a franchisor grants a franchisee the right to sell its products or services, including trademarks and trade names, in exchange for a franchise fee. There are different types of franchising, including product distributorship, where the franchisee sells a product with minimal control over operations, and business format franchising, which is more common and involves using a comprehensive business system developed by the franchisor. The Intellectual Property Code of the Philippines governs the use of trademarks and other intellectual property in franchising, ensuring that all technology transfer arrangements comply with licensing regulations to avoid practices harmful to competition. Timesharing. Timesharing is a property ownership model where multiple individuals share the right to use a vacation or recreational property for a specific period each year. So typically 1 or 2 weeks. The cost of owning the property and its maintenance is shared among the owners, with each person having exclusive use during their designated time. Timeshare agreements are regulated by federal and state laws, which require developers to provide full disclosure on project financing, contracts, and management details to ensure compliance and transparency. Taxes. Taxes on income in the Philippines are structured as follows. Individual income tax. Active business incomes for individuals is taxed between 5 to 32%, with exemptions for single individuals such as 20,000 pesos, heads of families 25,000 pesos, and married individuals, which is for 32,000 pesos. An additional 8,000 pesos exemption per independent up to 4 is also allowed. So, corporate income tax. Domestic corporations are taxed at 35%, reduced to the 30% in 2009, while foreign corporations are taxed based on their residency and income source. A minimum corporate income tax of 2% on gross income is applied after 4 years if it exceeds regular tax liability. Non-resident foreign corporations are taxed at 32% of the Philippine source income. Special economic zones. Business located in economic zones can avail of tax incentives such as income tax holidays and a 5% tax on gross income in lieu of local and national taxes, except real property taxes. Value-added taxes. In the Philippines, a 12% value-added taxes is levied on the sale, barter, exchange, or lease of goods and services, including imports. The VAT is calculated based on the selling price of goods or services, and businesses can deduct the tax paid on their purchases from the tax collected on sales. So if the output tax exceeds the input tax, the excess must be paid. But if the input tax exceeds the output tax, the excess is carried over to future periods with certain exemptions like export sales and agricultural products. Percentage tax. So the persons whose annual gross receipts do not exceed 550,000 pesos are exempt from payment of value-added tax but shall pay a percentage tax equivalent to 3% on quarterly sales. Domestic carriers and keepers of garages shall pay 3% of their quarterly gross receipts. So the international air carriers and shipping carriers doing business in the Philippines shall pay 30% of their gross quarterly receipts. Excise taxes. Excise tax is imposed on certain specified goods manufactured or produced for consumption in the Philippines for domestic sale on consumption or for any disposition and those imported. Excise tax is paid in addition to VAT. Alcohol products, automobiles, and certain luxuries items such as jewelry, precious metals, perfumes, and toilet waters, yachts, and other vessels intended for pleasure or sports are all subject to excise taxes. So the liability to pay excise tax accrues immediately upon removal of the goods from place of production or manufacture. Customs and import duties. Customs and duties are taxes on imports and exports, with importation starting when the vessel or aircraft enters Philippine territory and ending when the goods are released after paying duties or with legal permission. Imported vehicles are subject to 40% custom duties, so the 10% VAT and ad valorem tax based on their book value, which is determined from motor vehicle reference books, not the purchase price. Travel taxes. Travel tax is required for Filipino nationals, permanent resident aliens, and non-resident aliens who have stayed in the Philippines for more than 1 year before departure to other countries. Exemptions include Filipino overseas contract workers, Filipino permanent residents abroad staying less than a year, and infants under 2 years old, among others. Various documents such as employment certificates, income tax returns, or birth certificates are required for exemptions depending on the individual's status. Duty-free Philippines. Duty-free Philippines is a tax and duty-free shopping system designed to generate foreign exchange and revenue for the government, allowing specific groups of individuals to purchase imported goods without taxes. Incoming passengers can buy up to $250 worth of merchandise, while departing passengers may buy any amount provided it's under customs supervisions. Additionally, balikbayans are also allowed up to $1,500 in tax-free purchases, with certain conditions including a special $2,000 allowance for livelihood tools. Barangay Micro-Business Enterprise Law. The Barangay Micro-Business Enterprise Act of 2002 was established to encourage the formation of small businesses in the Philippines, offering incentives such as tax exemptions and local government support to promote economic development. Businesses with a total asset not exceeding 3 million pesos can apply for BMBE registration, which exempts them from income tax and the minimum wage law, while also providing easier access to government services. In the case of Mrs. Nanita Alnaides, her resort business qualifies for BMBE registration due to her capital being below the 3 million threshold, allowing her to benefit from the law's incentives. So let's end this chapter with a quote: "Work hard in silence, let success make the noise," by Frank Ocean. So focus on your goals and put in the effort without seeking attention, and let your achievements speak for themselves. So that's it, everyone, for my report. Thank you for watching. Once again, I'm Jade Claire Downing from BSHM 3A, and see you on the next chapter.